Joining us now to talk more about this is Kate Masur, professor at Northwestern University and a member of the Brennan Center for Justice Historians Council on the Constitution. Thank you so much for being here, Professor.
Thank you for having me.
All right, just how significant is this moment? How many people might be impacted by this?
Well, this is a really highly significant moment for the United States, for citizenship in the United States. The Supreme Court has not been asked to directly weigh in on the meaning of the Birthright Citizenship Clause of the 14th Amendment in a very long time. And the implications could be enormous. By one estimate, over 200,000 babies born in the United States every year to either undocumented or temporary residents of the United States could be rendered stateless by this executive order. And that number every year would continue to grow.
You filed what's called a Friends of the Court brief in this case, which is a legal document that aims to provide more information or context to the court. In it, you detail decades of advocacy for birthright citizenship by Black Americans. Can you talk a little bit more about that?
Sure. Well, originally, some of the first people who were actually denied birthright citizenship were Black Americans, free Black Americans before the Civil War. And they experienced a form of statelessness where some states recognized their citizenship, other states did not. They were extremely precarious in their ability to travel, to have jobs. They were vulnerable to mob violence. And much of that was because they were generally, or by many people, accepted from the principle of birthright citizenship that was widely just assumed to apply to the children of like European immigrants or to white children. And so part of the reason for the 14th Amendment, including birthright citizenship, was to remedy that. Free Black Americans demanded and said, look, we were born here, we're just as entitled to citizenship as white folks. And the framers of the 14th Amendment agreed with that and said we need to put into the Constitution a broad, inclusive principle that all children born in the United States are citizens of the United States, regardless of the status of their parents. There were some tiny exceptions, which we can talk about, but the broad, inclusive principle was intended to apply to pretty much everyone.
Well, kind of related to that, the Trump administration is arguing the 14th Amendment was only intended to cover the children of enslaved people. But since, of course, taking office again, the president has strongly supported all efforts to crack down on illegal immigrants, or even in some cases, immigrants who have filed for asylum. So what is your assessment of this executive order in this moment?
When President Trump says that the amendment was only intended to apply to quote unquote the babies of slaves, he's absolutely incorrect about that. At the time that the amendment was framed, immigration was a huge issue. There were tons and tons of immigrants coming to the United States at that point, and Congress actually discussed in that moment, well, is this going to apply to all the children of immigrants? They even talked about whether it would apply to the children of Chinese immigrants who faced an enormous amount of racism at that time. And Congress, the members of Congress who supported the amendment said, yes, this applies to all children of immigrants, regardless of the status of their parents. We have seen efforts to undermine birthright citizenship in the past, and they're almost always highly political and driven by anti-immigrant sentiment, not by any kind of legitimate understanding of the 14th Amendment.
And finally, and very quickly, for time purposes, do you think there is, or the court could find a loophole in the 14th Amendment that would back the president's order in some way?
I mean, the big argument right now that people on the president's side are making is around this, the phrase subject to the jurisdiction thereof, which is in the Birthright Citizenship Clause. The arguments that some legal scholars are making that clause should eliminate a whole lot of people from birthright citizenship, these arguments are, in my view, very preposterous. They're not grounded in facts. These are kind of novel arguments. Some of them have been used for a long time to undermine birthright citizenships. Others are kind of new inventions. In the end, these arguments have never won in court. They have never been supported by congressional legislation. These are marginal arguments that are being mobilized for political purposes.
Okay, professor and historian Kate Masur, thank you so much for joining me this morning. I'm sure we'll be continuing to discuss these arguments and the Supreme Court's eventual decision for months to come.
My pleasure. Thank you.